Ladies and gentlemen, welcome to the National Constitution Center. It is so wonderful to welcome you here on Constitution Day, the most exciting day of the year, and the 230th birthday of the U.S. Constitution. Happy birthday! It has been such an inspiring and extraordinary day here, starting at 8:30 in the morning, where a group of school kids recited the preamble to the Constitution on the lawn, then a beautiful naturalization ceremony for new citizens, which is among the most inspiring and moving ceremonies that I have ever been privileged to participate in, then an incredible discussion right in this room with Ken Burns and Lynn Novak on their new film about Vietnam, which premiered last night, and raises a series of constitutional questions ranging from the scope of First Amendment protections for protest to the scope of the war powers. Then a discussion with descendants of the plaintiffs in landmark Supreme Court cases like Brown versus Board of Education and the Tinker free speech case discussing the meaning of the Constitution. And then a speech by the patriotic philanthropist David Rubenstein about what every American should know about our founding documents, which distilled the lessons of the Constitution so precisely and intensely and meaningfully. And now, ladies and gentlemen, we are so honored to host a Constitution Day speech and conversation by the Deputy Attorney General of the United States, Rod Rosenstein. The National Constitution Center, as all of you know, is a special place that was created by the U.S. Congress to disseminate information about the Constitution on a nonpartisan basis. Thank you for reciting the congressional mandate. General, you see that our members are able to recite like congregants in a church, our beautiful nonpartisan motto. And that's why it's so appropriate that the Deputy Attorney General has chosen this place and this time to talk to us about the Constitution and the rule of law. He has an extraordinary career. I had the privilege of meeting him years ago when he came to GW Law School, where I teach, to talk about prosecutorial discretion to a criminal procedure class. He was sworn in as the 37th Deputy Attorney General of the United States on April 26, 2017. He graduated from Harvard Law School and was a law clerk for Judge Douglas Ginsburg on the U.S. Court of Appeals for the D.C. Circuit. He then joined the U.S. Department of Justice through the Attorney General's Honors Program in 1990, and he's prosecuted public corruption cases with the Public Integrity Section of the Criminal Division. He's been counsel to the Deputy Attorney General, Special Assistant to the Criminal Division's Assistant Attorney General, Assistant Attorney, U.S. Attorney in Maryland, and he's been U.S. Attorney for the District of Maryland from 2005 to 2017. This remarkable combination of prosecutorial experience and experience in the Justice Department will inform what he has to say to us today about the rule of law, the Constitution, and prosecutorial discretion. Please join me in welcoming the Deputy Attorney General, Rod Rosenstein. Thank you, Jeff. Thank you so much.
Well, thank you very much, and thank you, Jeff, for that kind introduction. I recall an engaging lunch with you a few years ago when I visited your law school in Washington. Your scholarship and your collegiality make you a superb representative of this institution. I'm so glad to see you here filling this very important role. The mission of this institution is to promote public understanding about our Constitution. This impressive institution keeps the spirit of the founding era alive. And what an ideal location for the Constitution Center. It looks out over Independence Hall, where our Constitution was written in 1787. It's also very convenient for me because I grew up not far from here, about 20 miles from this spot. And so I'm happy to be more or less back home. And I really appreciate the friends and family who are here today. You know, Benjamin Franklin's house also is very nearby. It's just a few blocks from here. And the story is told that after the Constitutional Convention, when Franklin was walking home from Independence Hall, he came across a woman by the name of Elizabeth Powell. And as the story is told, Mrs. Powell asked Benjamin Franklin, what sort of government had we created? Now, it's important to keep in mind that the Constitutional Convention was held in secrecy. Our government has difficulty keeping secrets these days, as you know. In those days, it was much easier to keep secrets. There was no internet. There was less gossiping in the media. So there actually was a fair amount of confidentiality about the deliberations that occurred over the Constitution. So when Mrs. Powell asked Franklin what sort of government had been created, it's significant that she did not necessarily know until after the convention what type of government we would have. Benjamin Franklin replied with these words, "A republic, madam, if you can keep it." Now, Mrs. Powell's question, as I said, illustrates that it was not inevitable that our country would be a democratic republic. We didn't evolve from a democratic republic. We didn't necessarily have to become a democratic republic. And Franklin's answer reminds us that it's also not inevitable that we would always be a democratic republic. The Constitution comes with a condition, which Franklin articulated: you need to keep it. And I was pleased, as Jeff escorted me around the center today, to see that that really is a consistent theme of the exhibits of this center. That is the obligation of the people to keep the Constitution. The word keep in modern English normally means to hold something in your possession. For example, here's a $10 bill. Keep the change. Keep, in that sense, is passive. But that's not the meaning that Franklin intended. He used the word keep in the same sense that we might say in modern English, keep the Sabbath. It means, it's an active verb. It means that there are things you have to do if you want to maintain it into the future. And some people think that it's up to politicians to keep our government, but Franklin spoke to an ordinary citizen on the street, and even more, a woman who at the time did not have the right to vote. And he said that it was her responsibility, not his, to keep the republic. The lesson is that each of us has a duty to keep the republic. But we often take it for granted. Consider the national anthem. Francis Scott Key wrote it as a poem during the Battle of Baltimore in the War of 1812. Key was watching the battle from a ship in the Chesapeake Bay. He used the flag that was flying over Fort McHenry as a symbol of American freedom. If the flag fell, it meant that the battle had been lost, and by implication, liberty had been lost. But Key was so far from the fort that he actually couldn't see the flag, particularly during the night. When the fighting stopped before dawn, Key did not know who had won the battle. So the poem begins with a question. Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming? Now today we sing that as a declaratory sentence. You can see the flag. But Key's punctuation conveys a different meaning. The first stanza of the Star-Spangled Banner is not a confident assertion that our flag will always be there. It's an anxious query. And the first stanza ends with another question. Just as it began, Key asks, oh, say, does that Star-Spangled Banner still wave over the land of the free and the home of the brave? Key was not certain whether our flag was still there. Now, the answer appears only in the poem's second stanza. In the second stanza of the poem, the sun rises and the flag is visible and all is well. Of course, most Americans never hear the second stanza. The ball game starts after the first stanza. We are so impatient. But it would surprise Key to hear Americans cheer after that first stanza because he intended it to convey a moment of uncertainty and peril. 2 centuries removed from the battle, most Americans ignore the question marks. It does not occur to us to ask whether our flag, and by implication our liberty, has been lost. But Key lived in a young nation that had just won its independence only 3 decades before and was in grave danger of losing it. Just a few weeks prior to the Battle of Baltimore, enemy forces had captured Washington, burned the White House, and raised the British flag over our capital city. We should never take our constitutional freedoms for granted. Supreme Court Justice Joseph Story observed that the Constitution is always at risk. Story wrote that it may perish in an hour by the folly or corruption or negligence of its keepers, the people. The words written in the Constitution by Franklin and his contemporaries protect our liberty so long as we adhere to the rule of law. But the rule of law is not just about words. The rule of law is about the character of the people who are responsible for keeping it. Judge Learned Hand wrote that liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. If the people responsible for upholding the law do it faithfully, then the result will be a high degree of consistency and predictability. Those features build public confidence, and they allow our nation to thrive. That's important because the rule of law is not just a feature of America. The rule of law is the foundation of America. One of the finest defenses of the rule of law appears in a play by Robert Bolt about Sir Thomas More, a man for all seasons. In Bolt's version, More defends the rule of law in an argument with his son-in-law, William Roper. Roper is angry that More would give the benefit of the rule of the law even to the devil himself. And using trees as metaphors for laws, Roper insists that he would cut down every tree, if necessary, to destroy the devil. More replies, "Oh, and when the last law was down and the devil turned round on you, where would you hide, Roper? The laws all being flat." The point is that if we permit the rule of law to erode, because at first it does not harm our personal interests, the erosion may eventually consume us as well. The rule of law is not self-executing. If it collapses, if the people lose faith in it, then everyone will suffer. In this administration, President Trump honors that principle by nominating judges who will administer justice without respect to persons, and by appointing Department of Justice officials who are faithful to the rule of law. Our Attorney General is one of those. Attorney General Jeff Sessions recently said, "No greater good can be done for the overall health and well-being of the Republic than preserving and strengthening the impartial rule of law." The Attorney General explained, "Societies where the rule of law is treasured tend to flourish and succeed. Societies where the rule of law is subject to political whims and personal biases tend to become afflicted by corruption, poverty, and human suffering." And tonight, I want to discuss the role of prosecutors in maintaining the rule of law. One of America's great attorneys general, Robert Jackson, once remarked, "The prosecutor has more control over life, liberty, and reputation than any other person in America." Now, courts exercise authority to rule on the strength of the evidence and the meaning of the law, but the most significant exercises of prosecutorial power are not reviewable by courts. Prosecutors have broad authority to decide what crimes to investigate, which people to prosecute, and what charges to pursue. In other areas of the law, where discretionary decisions are trusted to executive branch officials, there's judicial review, at least to determine whether they were arbitrary and capricious. But arbitrariness and caprice are not valid objections to criminal prosecution. The fact that police and prosecutors have the power to make arbitrary decisions has significant implications for the rule of law. After all, the rule of law is fundamentally about achieving justice by limiting government discretion. So to ensure the integrity of the criminal justice system, decisions about which cases to prosecute should be made in a rational way. It's important to understand the scope of prosecutorial discretion in a system of plentiful crimes and limited resources. In 1940, Attorney General Jackson remarked that if the Department of Justice were to make a pretense of reaching every probable violation of federal law, 10 times its present staff would be necessary. Well, the Department of Justice indeed has expanded far more than 10 times in the ensuing 77 years, but so too has the federal criminal code. The laws still outstrip the police and prosecutors available to enforce them. So Jackson went on to explain that no local police force can strictly enforce the traffic laws, or it would arrest half the driving population on any given morning, or evening, I should point out, for those of you who are driving home tonight. Now, in exercising discretion, Jackson said that we should prosecute the cases in which the offense is the most flagrant, the public harm the greatest, and the proof the most certain. The first level of discretion is about how to allocate our resources among the various types of crimes. For example, Do we increase the number of prosecutors devoted to narcotics cases, violent crime cases, or corruption cases? Do we encourage them to spend time on federal corruption, state corruption, or local corruption? In a system of limited resources, those decisions influence which type of cases ultimately will be prosecuted. Now, the second level of discretion is choosing which cases to prosecute within a given category. Of all bank robbers, for example, only a fraction can be prosecuted in federal court. Of course, we can prosecute in any individual case only if we believe we can prove the defendant's guilt beyond any reasonable doubt. But among the many cases that could satisfy that standard, how do we decide which ones to prosecute? And after resolving the question of which defendants to charge, prosecutors also exercise broad discretion about what charges to bring, because the defendants we prosecute often have committed a range of criminal violations, and so there are a variety of statutes from which we could choose. In 1978, the Supreme Court decided a case called Bordenkircher versus Hayes. That case arose after Mr. Hayes was charged under state law with forging a check for $88.30. It wasn't all that much money even in 1978. The charge carried a sentence of up to 10 years in prison. And the prosecutor made a plea offer, as we often do. He told Hayes that the government would recommend a sentence of 5 years if he were to plead guilty. But if he did not plead guilty, the prosecutor threatened to indict him under the state's three-time loser statute, which carried a mandatory life sentence because of Hayes' prior criminal record. Hayes declined to plead guilty. He was then charged as a habitual criminal. He was convicted, and he was sentenced to life in prison. Now, it's not quite as harsh as it sounds because this is a state that has probation and parole, but he would have served a long time, and he did serve a long time in prison. So the Supreme Court reviewed Hayes' claim. He argued that the prosecution had unfairly punished him for invoking his right to a fair trial. That's in the Constitution. But the Supreme Court rejected that claim. The court ruled that indicting a defendant for a lesser offense, as had been done there, and then elevating the charge, threatening to bring a more serious offense, is really no different in substance from indicting on a more serious charge in the first place and then bargaining down. That kind of plea bargaining is a fundamental aspect of the criminal justice system, the court held, and a lawful exercise of prosecutorial power. Defendants who are unhappy with the prosecution's decision to prosecute and the decision about what charges to bring find little recourse in the courts. The selective prosecution defense generally is the only means for a defendant to get judicial review of the decision to prosecute, but the threshold for a defendant trying to prove that is extraordinarily high. The selective prosecution defense gets at that feeling that you may have if you get pulled over for speeding. Has anyone had that experience? Sure, you broke the law, but as you're sitting there by the side of the road waiting for the officer to write up the ticket, hundreds of other speeding cars race by without getting tickets. And then you start to think about all the things that that police officer could be doing if he weren't spending his time ticketing you for speeding. So you drove 67 miles per hour in a 55 mile per hour zone. Don't they have any bank robbers to chase? Now, there are two thoughts that are going through your mind. The first is selectivity. Other people are committing exactly the same crime. I'm being unfairly singled out. And the second issue is proportionality. Other people are committing even worse crimes. The government should not spend its scarce resources on this violation. And the Supreme Court's answer to both of those concerns is that because there are far more crimes than there are prosecutors, judges, and jails, the government must exercise discretion about what crimes to investigate and which lawbreakers to prosecute. So proportionality is never a basis for a legal challenge to a prosecution. The argument that I did it, but other people did it too, just doesn't work. The selectivity argument alone also fails. You can't simply argue, I did it, but other people did it too. The Supreme Court ruled in a 1985 case, Waite v. United States, that judges will not consider selective prosecution claims unless the defendant proves both that other similarly situated persons were not prosecuted and that the government was motivated by discrimination based on an impermissible classification. In the Waite opinion, Justice Powell articulated the reasons why courts are ill-suited to review prosecutorial decisions. he described two categories of reasons. First, he said, prosecutorial decisions are based on factors that are not readily susceptible to the type of analysis that courts are competent to perform, such as the strength of the case, the deterrent value of the case, the government's enforcement priorities, and the relationship of the case to the government's overall enforcement plan. These are inherently executive branch considerations. And second, judicial review of the charging decision as opposed to the guilt. Keep in mind, judges always get to rule on guilt or innocence, but the judicial review of the charging decision would impose systemic costs. It would delay the proceeding. It would chill law enforcement by subjecting every decision to a searching review of the prosecutor's motives and involving outside scrutiny of the operations of the office. And it would undermine deterrence by revealing the government's enforcement priorities and strategy. If you knew what the threshold was, you could commit X amount of fraud or drive X miles per hour over the speed limit, that would undermine the government's ability to enforce the law. So WAIT stands for the proposition that a prosecutor can choose to indict for any good reason or no good reason. We just cannot act for an improper reason. Discretion is inherent in law enforcement. And when someone acts on a matter that's entrusted to their discretion, that decision is permissible regardless of whether it is wise. So discretion is the power to make a choice that is wrong, in the sense that it's not the objectively best choice that somebody else might make. But when government officials are vested with that sort of discretion, they have a special obligation to take care that they do make the objectively best choice, even when they're not required to. That takes wisdom. The Seventh Circuit judicial opinion described the challenge for federal prosecutors in these words: the Department of Justice wields enormous power over people's lives, much of it beyond effective judicial or political review. With power comes responsibility, moral if not legal, for its prudent and restrained exercise. And responsibility implies knowledge, experience, and sound judgment, not just good faith. Not just good faith. Of course, good faith is important, but the Department of Justice does not measure success by whether we acted with the right motive. Our goal is to make the objectively right choice based on articulable reasons. Prosecutors often talk about the value of independence. We want our prosecutors to be independent in the sense that they act without regard to partisan considerations. Independence is like good faith. It's important to be sure, but it does not guarantee the right result. Independent decisions also may be wrong. The most difficult management challenges for the Department of Justice involve prosecutors who act independently in good faith, but make unwise decisions. That's because acting with honor is no substitute for acting with wisdom. It's important to have the right motive, but it's even more important to do the right thing. And the necessary wisdom comes from experience. Now, some people think we should just defer to career prosecutors on the theory that their decisions will not be perceived as political. And deferring to career prosecutors is an easy policy to apply. It builds goodwill within an office. But deference is the opposite of principle. The best way to regulate prosecutorial discretion is to require detached review of significant cases by experienced career prosecutors who demonstrate wisdom, experience, fortitude, and detachment with oversight, as our system provides, by politically accountable officials. The supervisors need to provide meaningful scrutiny of proposed prosecutions, and they must not be afraid to say no. Detachment is critical to making wise decisions. Now, although our exercise of discretion is not governed by law, it's not reviewable in court, it is guided by internal policies. The Department of Justice established guidelines for how to exercise prosecutorial discretion. We call them the Principles of Federal Prosecution. They were first written in 1979 by then Attorney General Benjamin Civiletti. The guidelines don't dictate a particular result, but they are useful as a framework for considering why a case may merit prosecution. The premise of the guidelines is that prosecutors should use rational and objective considerations in selecting which cases to prosecute. But the guidelines counsel prosecutors to consider three categories of issues. First, the degree of federal interest in the prosecution as opposed to state or local interest. Second, the likelihood of effective prosecution in another jurisdiction, such as a state court, if not in federal court. And third, non-criminal alternatives to prosecution, because there will be some violations that may not warrant criminal prosecution because there are other sanctions, professional discipline and the like, that may be sufficient to deter that type of violation. And those principles of federal prosecution, they help us to guide our decisions. And they remind us about our duty to remain objective. Judge Learned Hand said that the spirit of liberty is the spirit which is not too sure that it's right. The spirit of liberty is the spirit which seeks to understand the minds of other men and women. The spirit of liberty is the spirit which weighs their interests alongside its own without bias. And that, I think, is the spirit of the Constitution Center. And I would add, in the criminal context, that the spirit of liberty is the spirit that requires the government to introduce evidence that proves a defendant's guilt beyond any reasonable doubt, so convincingly that it satisfies a jury of 12 randomly selected citizens. And that's a pretty high bar. Criminal prosecution involves using the power of the government to take away a person's liberty. And we should always exercise that care with judgment and wisdom. And we should strive to make our decisions impartially, without regard to political considerations. The Supreme Court proclaimed in Berger versus United States that the prosecutor's obligation to govern impartially is as compelling as its obligation to govern at all. To say that we enforce the law impartially does not mean that we enforce it mechanically or robotically. It means that we enforce it rationally. Disparate results should be justified by disparate facts. If prosecutors can bring charges that are motivated by an effort to make a political point rather than an objective need for criminal prosecution, public confidence in the rule of law would be jeopardized. Attorney General Jeff Sessions recently said that the Department of Justice does not represent any narrow interest or any subset of the American people. We represent all of the American people and protect the integrity of the Constitution. That is our charge. Those words convey a fundamental precept. The Department of Justice does not choose sides based on the identity of a party. We do not enforce the law against some people and ignore others based on bias or any improper consideration. Prosecutors are required to follow neutral principles and engage in impartial decision-making. Now, this process sometimes leads to unpopular results. Prosecutors do not need to explain the reasons for unpopular decisions. In fact, in many cases, it would be wrong to publicize our detailed reasons because they're based on confidential information. But we must have reasons. There should always be a good answer to the question, why did you prosecute that case? It will not do for the prosecutor to answer because I can or because I must. Must is overbroad. It implies the absence of discretion. Can is short-sighted. It betrays a lack of wisdom. The only right answer is because I should. Should involves accepting responsibility for a moral decision. In conclusion, I want to turn again to Robert Jackson, who opined that a good prosecutor should play fair, temper zeal with kindness, seek the truth, serve the law, and approach the task with humility. Humility is an essential attribute for guardians of the rule of law. Good judgment is also indispensable. The prosecutors who exercise their discretion wisely remain faithful to the rule of law and fulfill their duty to keep the republic. And so as we celebrate yesterday, our 230th Constitution Day, I propose in closing a toast to the rule of law. Thank you very much.
Thank you so much for that educational, informative, and substantive discussion of the history of prosecutorial discretion and the inspiring affirmation of the importance of the rule of law. This is an educational institution, and I want our audience to understand more about the way prosecutors make their decisions and the way they are regulated. And my first question is a historical one, and that is, what would Madison have made of the astonishing power you just described? At the time of the framing of the Constitution, there wasn't a lot of federal prosecutors or even a large professional police force. Most cases were decided by jury trials. Today, about 1 or 2% of all cases go to jury, and there's this huge prosecutorial force that is able to exercise the sort of unchecked power that you describe. So what would the framers have made of the modern prosecutor?
Well, that's a very good point. At the founding of the Republic in 1789, there were 13 prosecutors, a United States attorney in each of the states. And the United States attorney was a part-time employee. They had a private practice on the side. And they represented the government if and when cases arose that required representation. There wasn't even a Department of Justice. The Department of Justice as an institution was not created until the middle of the 19th century. And so you had an Attorney General in Washington who had some administrative responsibility, but really very little authority over those United States attorneys. And if you think about logistically how difficult it would have been if you're an Attorney General in Washington, even if they wanted you to exercise control, to reach out even so far as Baltimore, 40 miles away, let alone Maine or New Hampshire, without modern communication. So the U.S. Attorney was pretty much on, at the time, his own in making determinations about how to enforce law. But as Jeff mentioned, there wasn't that much of it. There weren't that many federal crimes. And so the role of U.S. Attorney in criminal law enforcement was pretty minimal. Most criminal enforcement for a very long time was state and local, and it's really a product largely of the 20th century that the criminal code began to explode and to, in many cases, overlap with state jurisdiction, to the point where today, in many of these cases, the issue for us really is what's our relationship with the local prosecutor, because he or she has authority over pretty much all the cases that we're prosecuting, and in cases that involve drug enforcement, for example, and even many violent crime cases, there are federal jurisdictional hooks that allow us to bring those cases in federal court. And so I think Madison, to come back to your question, Madison would be quite surprised by the extraordinary growth of the federal government, let alone the growth of the Department of Justice and the role of federal prosecutors in the modern democracy.
And then I should say, I'm going to ask the Deputy Attorney General some questions, and then you can ask yours too, so write them down on note cards as we're talking. There are other changes since Madison's time. Even as late as the 19th century, prosecutors couldn't issue subpoenas for things like private diaries or even for a commercial plate glass, because that was considered a violation of the Fourth and Fifth Amendments, which run almost into each other, as the Supreme Court said. But in the 20th century, the court abandoned many of those restraints and basically said as long as the subpoena gets information that's relevant to a legitimate investigation, the prosecutor can get it. What would Madison have made of that change?
Well, you're sort of making my point about the significance of prosecutorial discretion.
Yeah.
And in my view, as I mentioned, I think it imposes additional moral obligations because we do have that substantial power. As I said, the debate at the founding, for those of you who have visited the facility, the debate at the founding was largely over the power of the federal government, and in regard to the Bill of Rights in particular, the power of the federal government over individual citizens. The truth is that there were Federalists and Anti-Federalists, but none of them contemplated the extraordinary growth of the federal government that we've seen today. They were emerging from the Articles of Confederation, a very weak central government that was not effective in managing, at that time, a relatively small country. And so they certainly anticipated there would be a stronger national government. That was the point, but not to the extent that the national government would be so vast compared to state and local law enforcement. And the reality is, even today, about 85% of law enforcement is state and local. Now, you wouldn't know that from all the publicity and attention that is afforded to federal prosecutors, but still the majority of criminal enforcement involves local police officers and local prosecutors, not federal authorities. And so there's been a vast expansion of criminal law in general, but in particular, I think the members of the founding generation would not have anticipated, among other things, a capital city like Washington, D.C. that was so vast and powerful.
Describe more how it works in practice. When you were U.S. Attorney in Maryland, were there particular prosecutions you decided not to bring?
Absolutely. And I think, as I mentioned, I think that's the most important part of the job as a supervisor, is that you need to be prepared to say no, that you don't believe a case should be prosecuted. Typically, it's because you're second-guessing the strength of the evidence, but there are also cases where you question the legal justification or the commitment of resources to bring a particular case, because it's a significant commitment of our resources to prosecute the case, and then, of course, the resources all throughout the system, the time of the judge and the prisons and the entire system. So yes, an important component of being a United States Attorney is to set priorities for what types of cases are going to be prosecuted. It's not so much identifying particular people to be investigated, it's identifying where we're going to devote our resources, and then examining the bases for particular prosecutions. And I think that's an important part of management. The department, one of the many changes in the Department of Justice in recent decades is the professionalization of our staff. And I think that's largely a good thing, but it does change the dynamic, because up until about 30 or 40 years ago, it'd be rare to find a career federal prosecutor. Typically the route, once we started to hire assistant U.S. attorneys, because we had for a very long time only U.S. attorneys, once we started to hire assistant U.S. attorneys, it was for most people a short-term job that they would do for 2 or 3 or 4 years and then move into private law firms. You had relatively junior, relatively inexperienced people prosecuting criminal cases. Now we have a lot of career prosecutors, and that's important, particularly as laws become more complex and investigations take longer. It's important to have people who are around and who understand the rules and have that wisdom that I mentioned. But the challenge is that you have a different dynamic where you now have career prosecutors who have been there for a very long time and are going to be there, anticipate, for a very long time in the future, being managed by political appointees who typically are short-timers. I'm an exception to that because I served as U.S. Attorney for 12 years, but that's not the norm. And so that dynamic has implications as well for how you manage the office and how you set priorities. But I believe it's an important role of politically appointed leadership to supervise the cases, because if you're simply deferring to decisions being made down the chain, they may be right, but you're really abdicating a responsibility. So you do have a duty as the politically accountable official in the office to make sure that decisions are being made properly, and in the occasional, hopefully rare case, where there's some reason to question the judgment, you have a responsibility to correct it.
Are there historical examples of political appointees second-guessing career decisions to prosecute for political reasons?
Probably, but I would say it's very rare, and the reason it's very rare, it has a lot to do with the way the department is structured. There's a cost. If you're a political appointee trying to put a stop to a particular prosecution, there's a cost to that, because typically you'll have career investigators, maybe the FBI, DEA, ATF, or one of the many federal agencies, and you have career prosecutors, and if they're in agreement about a proposed prosecution, they're not going to like getting second-guessed. They're going to be skeptical about your motives. And so I think that the default is probably to be more differential. And that's why I said it's important, and one of the things that I emphasize to new U.S. attorneys is that you need to be prepared to make sure that you're comfortable with that case. You're the politically accountable official. Your name is going on every indictment, and you need to be prepared to stand behind it. So it's fine. You don't need to read every indictment. We don't have time to do that anymore. But you do have a responsibility to satisfy yourself about the justification for the case. And so that means, to get back to my original answer, there will be many times where you'll be accused of political motivation, but I think it's actually going to be relatively rare where people are actually motivated by politics. To give you an example, there was a controversial case several years ago, about 8 or 10, involving United States Senator Ted Stevens. And that case was indicted during the Bush administration, a Republican senator indicted during the Bush administration. And then it was resulted in a conviction which was overturned and resulted in serious allegations of misconduct, and eventually the case was dismissed by Eric Holder, the new Democratic Attorney General. And nobody was suspicious about that because it was a Republican administration that indicted the Republican senator. It was a Democratic administration that dismissed the case against the Democratic senator. But what if it were the other way around? Same people, same principled decisions, but there would be a basis for suspicion. And that's one of the reasons why, as I said, that our decisions are not always going to be popular. They're always going to give people an opportunity to accuse us of bias. But internally within the office, the reason why I don't believe there are going to be very many examples of that is that there's a professional ethic within the Department of Justice and any U.S. Attorney's Office. You've got a whole chain of command of people who are making objective determinations about the merit of the case, and for somebody to step into that chain and try to influence it, they have to be pretty confident that they're going to be able to persuade those folks they've got a legitimate reason for doing it, because there's no judicial oversight of that decision, and it's extraordinarily rare there's going to be congressional oversight of that decision. But there can be professional oversight of that decision. So we have in the department watchdog agencies. We have an Office of Professional Responsibility, which reviews exercises of prosecutorial discretion in some instances. We have an Office of Inspector General, which reviews certain types of allegations of misconduct. And so if you're making an unpopular decision, you need to be prepared for the possibility that there may be a review, not judicial, but at least administrative. And I think that serves as an additional check on top of the culture, which is the primary check, that reduces the possibility of any kind of improper political influence.
Perhaps the most famous defense of your argument that political checks are necessary on prosecution is the late Justice Scalia's dissenting opinion in Morrison and Olson upholding the independent counsel law. And Justice Scalia said when you have an unaccountable prosecutor not reviewed by political appointees, then they may threaten liberty and use resources in unjustifiable ways. And both Democrats and Republicans seem to have accepted that argument. No, this is a historical constitutional question. The next one is the modern one. The Democrats and Republicans seem to accept Justice Scalia's argument when they allowed the independent counsel law to lapse. Were they correct, and was Justice Scalia correct?
Yes, although I worked for an independent counsel. I think people who work for independent counsels. And again, this is different than a special counsel. Independent counsel is actually independent, fully 100% independent, unaccountable, really to anybody. And that was the objection of the independent counsel regime, was that the independent counsels were selected by the courts. They had essentially the authority of the Attorney General, and they were not accountable to the Department of Justice. So if you're unhappy with the decision of an independent counsel, you really don't have any recourse. And in fact, one of the defendants that I prosecuted, Susan McDougall, was quoted once saying, who do I complain to? And she had a point. Now, I think the case was justified, but she had a point in the sense that structurally, the independent counsel stands alone outside the Department of Justice. And so that's how I feel about the independent counsel regime. And Justice Scalia, it's a fascinating opinion. I've taught, actually the class where you and I met, I've taught about that. It takes a long time to fully articulate it. We don't have that much time. But Justice Scalia, in his dissent, it was one single dissent in the case. Everybody else thought the independent counsel statute was constitutional. He objected structurally. As he said, the prosecutorial power should not be shifted entirely outside the Department of Justice. But then also the most interesting part of his opinion that Jeff has referred to is he added an entire section on why it was a bad idea as a policy matter, setting aside the structural or constitutional objection, why it was a bad idea as a policy matter. And I spoke about Justice Powell's objections in Waite versus United States, the institutional reasons why courts are not well positioned to review the exercise of discretion. And Justice Scalia essentially adopted those arguments in explaining why the prosecutorial power is inherently discretionary and therefore belongs in the accountable executive branch.
So the modern question is just a procedural one, because obviously you can't comment on the case, but explain to our
I knew you were headed there.
I have to ask, because I'm curious, what is the difference between a special prosecutor and an independent counsel, and how are the special prosecutor's decisions reviewed? Ultimately, you review them, but what standards do you use in reviewing the special prosecutor's decision?
So I'm not going to answer all your questions about that. But actually, I was asked this question. Some of you may have seen it in an exchange in the United States Senate. And they have 5 minutes per senator, and that is not enough time to answer that question. It's a complex question. The answer is, though, as I suggested, that a special counsel, and you can't be too confused by the terms. There have been various iterations of special prosecutors and special counsels over the centuries, really. But the independent counsel was unique because it was a statutorily created institution that was unaccountable to the executive branch. The special counsel under the regulation that's now in effect in the Department of Justice, adopted in 1999, is not fully independent of the executive branch. It has a degree of independence, that's how I've described it, and it has accountability for the Attorney General or acting Attorney General in the sense that if you were to overrule a special counsel, you have an obligation to report to the Congress, and they can be a pretty effective watchdog. But structurally, it is within the Department of Justice, and the regulation was written with that in mind. It was written as an alternative to the independent counsel regime, and the concept was that there might be cases where, for whatever reasons, we need some degree of independence from the traditional department structure, but we still want accountability. And so the special counsel under the regulation is required to follow policies, procedures, and practices of the Department of Justice. And if they were not to follow them, then they're subject to oversight by the Attorney General.
Great. Well, you can see this phenomenal stack of questions from our audience. I've just put on my constitutional reading glasses and I'm looking on them in real time. And here's the first one related to what we're talking about. How can a prosecutor make truly impartial decisions when they report to political persons who can discipline or fire the prosecutor?
So, that is a very logical question. Who asked it? You don't need to raise your hand. And my answer, though, is that I have a very different perspective, and I actually had this experience of trying to explain to legislators who have not been prosecutors. It's about the culture of the Department of Justice. It's just the way we operate. We train people that way. It's not that we hire people who are nonpartisan, right? I mean, most educated people have political views. It's that we insist that they conduct themselves within the office in their professional capacity in a nonpartisan way. And we all know how to do that. Set aside your political considerations and look at the objective facts of the case. And that is reinforced by as I said, the culture of the office, and it's reinforced by the structure, by the chain of command, that you have to justify what you're doing. Now, people could just run out and return an indictment, for example. You wouldn't have that much confidence. But what we do is we require people to articulate, to write down and explain the reasons why a case ought to be prosecuted. And the more controversial and sensitive the case, the more rigorous the review. The longer the memos and the higher in the chain of command the matter gets reviewed. And so that is the assurance. It's not that we have people without political views who are involved. It's that we have people who are trained in setting aside their political views because they believe in the rule of law, right? Same issue as judges. It's not, judges are not people who weren't politically involved. In fact, somebody once gave me some advice. Said, if you want to be a judge, don't register independent, because Republicans like to appoint Republicans and Democrats like to appoint Democrats. It's not the absence of personal views. It's the mindset to set those partisan issues aside and just look at the facts in the law.
There are a number of questions, obviously, on this subject, and you can answer them as you feel best, but here's a representative one. At what point did you decide to appoint an independent counsel, and why did you not inform the president?
Never, right? I never decided to appoint an independent counsel. I appointed a special counsel. I'm not going to obviously go into any detail about that. I appointed the special counsel about a half hour before I told you in a press release that I appointed the special counsel. Obviously, as Jeff is adverting to, as the question suggests, that decision is not made on the spur of the moment. It's a product of a deliberative process, and I'm not going to go into that.
These are not all on that topic, but one or two more related ones. How does the concept of the rule of law apply to President Trump's decision to fire FBI Director Comey, and by dint your decision to appoint a special prosecutor?
Well, there's an unstated premise in the question. If you presume that there was some improper reason for firing Jim Comey, and you're free to exercise your opinion, then you would be concerned about it. But I think what's important to recognize is that the president does have a right to fire any presidentially appointed employee. That includes me, the FBI director, the ATF director, the U.S. Marshal Service director. Who can he not fire? He can't fire the judges, and he can't fire the career employees of the department without some finding of misconduct. But keep in mind that the whole concept of our politically accountable executive branch is that the folks who run the executive branch, people like me, are not selected purely by merit. Hopefully merit has something to do with it, right? But it's not a competitive merit-based process. It's a political appointment. And I've been in the department for a very long time. And for most of my career in the department, I was responsible for career hiring. And there are very strict rules about how you go about hiring and firing people who have career protection in the Department of Justice. That's one of the things that maintains their independence. In the process of appointing political appointees, for example, U.S. attorneys, which I've been involved in, and FBI and DEA and ATF leaders, those decisions, there's a significant component of merit to it, right? You want somebody who's certainly going to be qualified for the job. But it's a decision about who the president and the administration think is best going to be able to faithfully implement their priorities. And with U.S. attorneys, it's even more complicated because traditionally there's some degree of deference to the senators in the state. Senators don't always get to pick the U.S. attorney, but they get to have some say in the selection of a U.S. attorney. So it's, in some cases, a compromise. And so the upshot is that a decision to fire any politically accountable official is vested in the president. He has the right to appoint his own people. That was sort of inherent in the fact that the FBI director has a 10-year term subject to removal by the president and not an unlimited indefinite term. You could write a statute that protected an official in a job like that. In fact, there's been some talk about it, but they didn't do it. And one of the reasons they didn't do it is because there was an FBI director named J. Edgar Hoover who people felt was in the job too long and was too powerful and wasn't subject to control by the politically accountable officials. So, as I said, you're free to reach your own opinion based upon whatever facts you may know about it, but on the principle, I think it's important, it's inherent in the way our constitutional system is designed, that the president does have the ability to hire and fire the people he wants for these positions, subject to Senate confirmation. The Senate has to confirm them on the way in. The Senate does not have to approve on the way out. And traditionally, of course, almost all political appointees leave upon the election of a new president. So most officials, presidentially appointed officials, left on January 20th, and there's nothing wrong with that. That's contemplated by the constitutional design and by the statutory appointment authority.
Another question about executive power. What is the rationale to give the president power to pardon virtually any federal crime? And does there seem to be any interest in the Congress or Senate in modifying this? And would the Constitution allow modification?
Oh, great question. Who knows if the Constitution allows modification? Yes, it does, right? There's an amendment process. And so, yeah, very perceptive question. The pardon power is in the Constitution. Presidents have exercised it before. I've been involved in multiple cases personally in which presidents have exercised the pardon power. I mentioned I was involved in the prosecution of Susan McDougal. Bill Clinton pardoned her on his way out of town. I was involved in the prosecution of James Cartwright. President Obama pardoned him on his way out of town. The Cartwright case actually was somewhat analogous to the recent pardon in the sense that he had been convicted. He actually pleaded guilty and was awaiting sentencing at the time that the president granted the pardon. So there's no dispute that that power is vested by the Constitution in the president. There's no more significant power than one that is expressly written into the Constitution. And the reasons why they wrote that in, I think it's a reflection probably of their received wisdom. They were products of a monarchy where the king had that power, and they thought that the chief executive of our government should have that power. And if we change our minds, there is an amendment process, and you can learn about it upstairs.
Just a few more. These are all great questions, and there are a bunch of them about this topic. Given your remarks about prosecutorial discretion and the spate of cases involving the killing of black men by police, how do you think history will judge the prosecutors and the decisions?
So I think it's a mistake, you probably can infer this from my comments, it's a mistake to ask for a categorical answer to that. I feel the same way when you see people who are protesting, which is fine and legitimate and protected, but when they're protesting by attacking innocent police officers. That's no better than attacking innocent citizens, throwing bricks and rocks and bottles at police officers who are standing there trying to keep the peace. You can't generalize in law enforcement. Each case is evaluated on its own merits, and sometimes we know all the relevant facts, and so we can fairly criticize it from outside, but most of the time, we actually don't know all the relevant facts. And so in most cases, a verdict, an acquittal, let's say, is a product of a jury deliberation, and there isn't necessarily going to be a single reason, and it's certainly not going to be written down because it dissipates when the jury disbands. In cases that are tried to judges, typically you do get a reasoned opinion. So in Baltimore City, for example, the judge who handled the prosecutions of the acquitted police officers in the Freddie Gray case, when there was an acquittal, articulated reasons. There were also cases with hung juries. In the case in St. Louis, the judge in that case issued a lengthy and very detailed opinion, and you probably haven't read it. I haven't read it either. But I know somebody who did, who told me, you know, it's a very thorough and reasoned opinion, and it's a reflection, in the short answer to the question, of the fact that you cannot generalize about our criminal justice system. That's the whole point of requiring proof beyond a reasonable doubt. It's a very high standard. You need to, the decision maker, whether it's a jury or a judge, needs to be convinced to, beyond a reasonable doubt, very high threshold, the highest we have in the law, that the defendant is guilty. And so it's designed that way to err in which direction? It's designed to err in favor of the defendant, in favor of the citizen who's accused of wrongdoing by the government. And so as a result of that, it's just wrong to generalize about these cases.
Two final questions. First, thank you so much for being here this evening, says the questioner. And then, to understate the obvious, lawmakers are not infallible. There are likely to be times when a prosecutor is faced with the prospect of enforcing a law that he or she does not believe is just. How would you counsel a prosecutor facing such a situation?
There certainly have been unjust laws in the past. I think now there are laws that people have disagreements about, and that's fine in a democracy. But there have been unjust laws, you know, for example, laws that discriminated based on race and that sort of thing. What I tell our prosecutors is that there's sort of a range of permissible discretion. I talked a lot about discretion. If you come to join the Department of Justice, you don't have liberty to do whatever you like. You know, we have 115,000 employees. We can't have 115,000 different decisions being made. We have to have some consistency. That's what the rule of law is about. And so as I described, we have a supervisory chain of command. We have, you know, people who have input, and within a range of reasonableness, we may have an attorney who wants to go here, and we tell him you have to go here, and it's within the range of reasonableness. But what I describe to our lawyers is, and one of the perks of being a government lawyer is, I don't want you going into court advocating for a case where you think that it's wrong. And so if a case you believe is sufficiently outside or so far beyond the range of reasonableness, we actually allow our prosecutors to withdraw. And I'll give you one concrete example. When I was U.S. attorney, we had cases that involved the death penalty, capital crimes. We had attorneys who were unwilling to prosecute capital crimes, and I was not going to make them go into court and prosecute a case. Number one, they're not going to be an effective advocate if they don't believe in it, because that's a principle of ethically what we do as prosecutors. We need to believe in the merit of our case. And number two, it's not fair, you know, somebody who has that view, to force them to seek the death penalty when they have a conscientious objection to it. And so that would be my answer. I think you're not going to have extreme cases like we might have had if we went back half a century or more. But there may be cases where people have, you know, moral objections, and the Department of Justice accommodates them.
Last question, which is a great one for Constitution Day. What Supreme Court justice throughout history best represents your constitutional analysis and your perspective for preserving the rule of law in American democracy?
So I think that there are a lot of ways that I could answer that question. And fortunately, most of our Supreme Court justices qualify, maybe all, in the sense that they're all committed to the rule of law. You know, that's the principle of judging, really. There are some who vary more than others, you know, who are more willing to consider things that aren't necessarily in the written law. And so there are a lot of different ways I can answer that question, but in this context, I have to say Robert Jackson, because as a prosecutor, you know, he's been my role model. Robert Jackson was official in the Department of Justice. He had several roles, Solicitor General and Assistant Attorney General for the Tax Division, and of course, Attorney General. He became a Supreme Court justice. He took a leave of absence and became a judge at Nuremberg. I don't think they would allow that these days, but they did in the 1940s. And so if you look at what Justice Jackson has said about the prosecutorial power, he's certainly a role model for me and would be my number one choice in terms of a justice to emulate who understood how to use the prosecutorial power to acknowledge the discretion, but to exercise it in a way that's consistent with the rule of law.
I can't resist the follow-up. He was criticized for bungling the cross-examination of Goering at Nuremberg. Was he wrong to go to Nuremberg, and what does the Nuremberg experience suggest about his legacy as a prosecutor.
Well, Jeff, you've already demonstrated more expertise than I on that issue, so I don't have any opinion about that. I think it came up today, as I said. I mean, there's so many things that were done in the past. You look at it now as a prosecutor and you don't understand it because the rules were different. I mean, we didn't even have an obligation to disclose exculpatory evidence. If you're a prosecutor, you know that there's evidence suggesting somebody's innocent, you could keep it in your file and go to trial and convict somebody without disclosing it to the other side up until, I think it's 1963. And I mentioned, U.S. attorneys used to have private practices. It was a part-time job, so there were all sorts of conflicts that we wouldn't allow today. And so I think it's difficult to, I wouldn't criticize Jackson based on our modern conception, but certainly today, you would not want a Supreme Court justice taking a break to go to a foreign country and serve as a prosecutor. You're a prosecutor at Nuremberg, not a judge. If for nothing else, than the fact that we need an odd number of Supreme Court justices in case there's a tie. So I would be against it, but I wouldn't criticize him for the decision he made. That was an extraordinary moment, obviously, in world history. And I certainly don't have any opinion about whether he bungled the cross-examination, although I do trust generally Jeff's judgment about things like that.
Hardly so. General Rosenstein, these are polarized times. And for you to take the time to come to the Constitution Center, to educate Americans about the rule of law, and to uphold a vision of nonpartisan prosecutorial discretion is inspiring. Thank you for all you're doing for America, and thank you for coming to the National Constitution.
Thank you very much. Appreciate it. Thank you. That's great. Thank you. Thank you for the invitation.